Hello, everybody. Welcome to today's Train the Trainer webinar on helping homeowners avoid foreclosure. My name is Nelson Santiago, and I am a community outreach manager with Consumer Action. I'm thrilled that you are joining us today. We have a fantastic program in store for you. In case you're unfamiliar with Consumer Action, we are a national nonprofit consumer education and advocacy organization founded way back in 1971. Over the years, our consumer education work has focused on a wide range of topics, including personal finance, telecommunications, insurance, privacy, and of course, housing, which is the topic bringing us all here today. Before we get into the program, I want to acknowledge and thank our project funder. We are able to present this webinar thanks to an AHEAD grant from the Federal Home Loan Bank of San Francisco, which we were able to receive thanks to our longtime Arizona-based partner, Desert Financial, a nonprofit credit union member of the Federal Home Loan Bank of San Francisco. Big shout out to Desert Financial for their support. As part of this project, we created a fact sheet titled Housing Help, Next Steps and Resources When You're at Risk of Foreclosure. The fact sheet is available in English and Spanish, and we'll be sending you a direct link to it in a follow-up email in about a week. The follow-up email will also include the recording link, a copy of the slide deck, and information that AFCPE certified professionals can use to obtain their continuing education credits. Now, moving into the program for today, let me tell you about the incredible speakers that we will hear from. With us today from Tucson, Arizona is Araceli Jimenez. Araceli is a HUD-certified housing and financial counselor with Administration of Resources Choices, or ARC. ARC is a nonprofit that strives to create family stabilization by securing housing for underserved populations through the provision of resources for new home buyers and distressed homeowners and renters. ARC also serves critical needs of neglected elderly consumers who are in need of safety, assistance with their care, and housing stability. Araceli has 20 years of work experience related to housing and holds an associate's degree in administration. Prior to working at ARC, Araceli worked for 5 years at the Primavera Foundation, where she handled the pre-purchase program and taught homebuyer education classes. Welcome, Araceli. We will also hear today from Andrea Bopp Stark. Andrea is a senior attorney with the National Consumer Law Center at the Boston office. She focuses on writing and teaching about fair debt collection practices and mortgage servicing issues. She's also involved in advocating for foreclosure prevention and fair debt collection policies on the state and federal levels. Previously, Andrea was a partner of Moliere Law Office in Biddeford, Maine, and worked as an attorney for Northeast Legal Aid in Lawrence, Massachusetts, where she was one of NCLC's first recipients of the John G. Brooks Fellowship. Welcome, Andrea. And last but not least, we will also hear from Stacey Tutt. Stacey is a Homeowner Assistance Fund coordinator and senior staff attorney with the National Housing Law Project. Stacey's work focuses on the national implementation of the Homeowners Assistance Fund on predatory lending, mortgage servicing, and energy efficiency housing finance. Prior to joining the National Housing Law Project, Stacey designed and directed the Consumer Law Clinic at the University of California Irvine School of Law. The Consumer Law Clinic focused on keeping low-income consumers in their homes after experiencing home improvement fraud. Stacey also developed and directed the Community Preservation Clinic at the University of Illinois College of Law, which among other things provided foreclosure defense to vulnerable homeowners. Welcome, Stacey. We are so glad you are here. If you have questions for our speakers, you can type them into the question function, and we will get to them at the end of their presentations. Stacey, I'm trying to give you control of the mouse. See if you can advance the deck.
It looks like it's working, Nelson. Thank you
Great.
so much. And I want to thank everybody for being here with us today to discuss this really important topic of trying to help homeowners avoid foreclosure. So as we go through today's presentation, we are hoping to try to help you understand who are the players that are out there, when and why does foreclosure happen, and really this is to provide you with a broad overview of the assistance struggling homeowners need in order to prevent foreclosure. Our hope is by bringing HUD-certified counselors, legal service providers, and community-based organizations together, we can better assist these struggling homeowners. So what we are going to take you through is, in part, with our panel here, we have legal service providers and HUD-certified counselor as well, to share with you how we work with homeowners and the difference we can make in trying to help them keep their homes. So to start us out with this, we presented this agenda here for you of what we're going to be talking about and going through in this presentation. But we thought we'd like first to start out hearing from Araceli, a HUD-certified counselor who works directly with homeowners on a regular basis and helping them address foreclosure. So Araceli, I'm going to turn it over to you so you can share with us some of your frontline experiences working with homeowners.
Thank you, Stacey. Good morning, everyone. Okay, my job is to describe how traumatic foreclosure could be in the life of these families. A foreclosure is a very traumatic experience because that can take a significant emotional toll of homeowners. When a family loses their home, it's not just a loss of property, but also a loss of security, stability, and often a piece of their personal identity. So I'm going to share with you one of my stories. A client I had around 2015. We're going to call him Mr. Lopez. This client, it's a family of 4, him, wife, and 2 children. Mr. Lopez worked at a place where he operated heavy machinery. One morning, one of his arms got tangled in the machine, cutting it completely. Wife was not working, taking care of the house and the children, no other income in the house. The difficult moment for us as counselors is when the family sits in front of you. You can see the anguish in their eyes. Our job is to give them words of comfort and make them focus on what they brought them to us, identify their needs, and find a solution. And a solution is not always to keep the home. But I'm going to stop here so Stacey and Sandra will talk about more about options in this process.
Wonderful. And before we talk a little bit more about what brings about foreclosure, first I wanted to take an opportunity to describe the different financing that may result in foreclosure, as well as just share with us all some common terminology as we're going through this kind of complex area of financial security. So in particular, the types of loans that can be subject to foreclosure are loans that are taken out in order to buy a home. We often refer to those as purchase money mortgages. So that means someone has taken out that financing to buy a home. Now, our next term in which there can be a foreclosure is if that home is refinanced. What do we mean by refinancing? That's simply going back in and requesting and applying to change the terms of the loan that the person has received. In some instances, a refinance may allow a homeowner to take some money out of their home to use for other things. And other instances, it may be to be able to benefit from low interest rates or improve the terms of their mortgage in order to help them make it more affordable. Another type of loan that is subject to foreclosure is what's called a first lien. Now, oftentimes a first lien may be that purchase money mortgage that allowed the homeowner to buy the home. But the idea behind this first lien is what it means is that someone owns a property. However, a creditor has come in and now says that they have an interest in the property because they are owed money. So that means that the property is ever sold, then that is the person who needs to get paid first before anybody else. Now, there can also be instances in which there's a second lien on a home. Oftentimes, a second lien can be put on a home if a homeowner decides to take out what we'll talk about next, a home equity loan or a home equity line of credit. It can also happen, though, if an individual homeowner has debts and maybe has a money judgment against them. In those instances, a lien can also be filed recorded against the property. But in the instance of a second lien, whenever the property is sold or maybe refinanced, the second lien will not be paid until the first lien is the one that's paid. The next type of loans that we're going to talk about are just where this could come up, where we have foreclosure, is a home equity loan. Now, that's where a homeowner takes money out of their property, oftentimes in order to make repairs to the property or to just address other financially challenging circumstances. A home equity loan is usually for a set amount that they are able to kind of tap into that equity in their home. When I say tap into equity, really what I'm talking about there is that the home is worth more than the debt associated with it. So then homeowners may be able to borrow more money using their house as a security interest in order to have access to that credit. So again, a home equity loan is typically for a set amount, whereas we also have here what's called a home equity line of credit. What this actually allows a homeowner to do is tap into that equity of their home, but it's not for a set amount. Now, there's a set amount that they're eligible for, but it's the idea that they can maybe take out a small portion of it and then go back in and take out even more if it's necessary in order to address their financial circumstances. Another type of financing that's out there that you may have already heard about is what is called a reverse mortgage. Now, this is a very unique type of loan, but it is also subject to foreclosure. What's unique about a reverse mortgage is that it's only available to older adults over age 62, and it allows them to tap into the equity in their home in order to meet their ongoing expenses. So what that actually means in most circumstances with a reverse mortgage is that the homeowner doesn't have a loan associated with it or a small mortgage. And what they do then is apply for a reverse mortgage. The reverse mortgage will provide them either a line of credit or a large lump sum amount at the time the reverse mortgage is taken out. And then after the reverse mortgage is closed, the homeowner actually doesn't owe any ongoing payments, because what this reverse mortgage does is allow them to tap into that equity in their home and rely on that for financing the mortgage. So unlike a purchase money mortgage where you make monthly payments and the balance goes down, in a reverse mortgage situation, that balance is going to continue to go up every month because the homeowner is not required to make any payments, but the amount of that balance will continue to increase with interest and other charges associated with the financing. The value of this financing is that that balance does not become due unless the homeowner is no longer able to remain in the home for over a year, or the homeowner passes away, or the property is sold or otherwise refinanced. So oftentimes older adults will choose this option because they have equity in their home, but what they lack is enough money to meet their ongoing financial concerns. So they'll take out a reverse mortgage to tap into that equity. It should be noted, though, with reverse mortgages that, again, that balance continues to go up. So homeowners that take out a reverse mortgage are not going to be able to simply give their family members the property upon their passing, their heirs. Instead, that reverse mortgage will have to be paid afterwards in order for that property to transition to any heirs, which often is not something that is feasible. So not to go too long into that, I just wanted to mention that and give a description given the unique nature of reverse mortgages. In addition to these types of loans that we just discussed, there are a lot of other alternative financing that is out there, such as a contract for deed, or sometimes these may be financing that's allowing for the purchase of a manufactured home or other types. And so just to kind of put that out there, that there is a broad range of loans and different kinds of financing that may subject a homeowner to foreclosure, or another way to put it, to potential loss of that property. So now that we've seen a little bit more of the different types of loans that are subject to foreclosure, I did want to just touch on and talk a little bit about the reason that homeowners fall behind. Now, I wanted to bring this up is because recent research has come out to show that really the reason people get behind on their mortgages, 94% of them, can actually be explained by negative life events, like the ones listed here in our slide. These can be reasons that can, increase the cost for individuals or decrease the income available to them, which then leaves them falling farther and farther behind and potentially facing foreclosure. And again, I brought this up because there was research following our last foreclosure crisis that we had, the Great Recession, that seemed to indicate that sometimes homeowners chose to strategically default on their mortgages if they owed more than the home was worth, or as we call it, they had negative equity. And again, the research had originally thought that maybe 30 to even 70% of the foreclosures during the Great Recession were related to strategic default. But now the new research is showing, in fact, 94% of homeowners get behind because of negative life events. But one of the main reasons people get behind are oftentimes because of the fact that they actually have what we call a high cost mortgage, a mortgage that may have a very high interest rate or have a term like a balloon note. What a balloon note means is you make regular monthly payments, and at the end you are owed a very large lump sum payment. Those kinds of what we call high cost or subprime loan terms are also a leading clause for people to go into default, and that having a high cost subprime loan may put you at risk 860% higher chance of going into foreclosure than other loans. So again, there are a number of factors that happen. And why do people go into high cost subprime loans? Oftentimes that happens through lack of knowledge of other options that are available to them. It can also happen because of their own credit score or history in which they are then appear to be a greater risk to the lender that will charge even greater interest or cost to cover that risk. So hopefully this again gives you a better understanding of what causes foreclosure and what our homeowners are experiencing. But now we want to speak with you a little bit about how to get help and how to help homeowners through this process. So at this point, I'm going to turn it over to my co-presenter, Andrea from the National Consumer Law Center, who's going to take us through understanding the different types of loans and players involved.
Great, thanks, Stacey. Hi, everyone. This is Andrea Bopp Stark from the National Consumer Law Center. I want to talk to you about understanding the different types of loans and the different players of who owns these loans, who's involved in these loans. You just heard from Stacey the different kinds of mortgages that a homeowner might take out. Well, who's involved in those mortgages? And why is that important for you to know and to learn about? It's important because whoever owns that loan decides what options are available when a homeowner falls behind. So if a homeowner is in default and behind on their mortgage, they're going to look at different options to get current and cure that default. And the owner is the one who has the rules and guidance to help the homeowner become current, and the mortgage servicer is the one who is going to help that homeowner and work with that homeowner to become current. So it's important to go over this just so you know how you can help your clients when they come in with a foreclosure. So who owns or insures the loan? So who owns the loan is very different from who services the loan. So the owner of the loan could be, you've probably heard of Fannie Mae, Freddie Mac. There's also FHA, which is the Federal Housing Administration, VA, Veterans Administration. Also, it could be a rural housing loan through USDA, RHS, or RD. And then, as Stacey said, it could be a reverse mortgage or what's called a HECM. And then if it's not one of these government-backed entities, it could be privately owned by a securitized trust. or some other investor. So that's the owner. They're the ones who create the rules. And then the servicer is the company that the homeowner sends their monthly payments to. The servicer handles the day-to-day tasks of managing the loan. They provide notices and communications to the borrower. And this is who the borrower and you are going to communicate with and connect with to try and get that borrower back on track, to try and cure that default, to avoid the foreclosure. Okay, next slide. So how do we know who owns this loan? And that's the first thing, is to figure out who owns the loan. So with Fannie and Freddie, it's pretty easy. They have a lookup tool online, and we've provided the websites, but you really could just do Fannie lookup or Freddie lookup in Google, and it will bring you to these sites. And you enter the address, some information about the address, the last four of the social with your client's permission, and then it will tell you, is this a Fannie or Freddie loan? And just a caveat about that, make sure it's a Fannie or Freddie loan. If it says yes, it's a Fannie loan, for example, you want to just confirm that with the mortgage servicer. Sometimes these loans are sold, and once these loans are sold, they are not Fannie and Freddie anymore, and so the Fannie and Freddie rules do not apply anymore. So just be careful of that. But it's really important to first figure out who owns this loan so you know what rules and guidance you are working with to try and get your client back on track. And so now I'll turn it to Stacey to go through government insured loans.
And just as Andrea described, it's important to know if a mortgage is a government insured, because it may mean that that homeowner has some additional protections or there's requirements for the owner and servicer of those government insured loans. So who insures those loans? It could be the Federal Housing Administration, the Veterans Administration, or the rural housing services. And we bring again this up because this covers about 25% of all residential mortgages. So since they have such a portion of the market, we find it's important to just go through and describe how homeowners can identify if their government mortgage is insured. And what does it mean if a loan is guaranteed or insured, and why do we have this in the first place? Well, what it does is that it does, the federal entity that is insuring it is guaranteeing that the loan, that the owner of the loan will be compensated for a loss if the home goes through foreclosure. So that governmental entity is going to repay the lender the remaining amount owed if the foreclosure does not make them fully whole of their cost. Now, what is valuable about this is that it actually helps create more affordable housing. Oftentimes, FHA mortgages can have more generous terms that will allow first-time home buyers to be able to purchase their homes. Such things as a lower down payment or just overall better terms for them in order to help with affordability. And again, it's important in this concept too, not only because a guaranteed or insured loan helps increase and affordable housing opportunities, it can also create more protections from borrowers if they do get behind on their mortgages. So how can you tell if the loan is government insured? Well, one thing is that the monthly statements for an FHA insured mortgage would likely have included with it what's called mortgage insurance premiums. What are mortgage insurance premiums? That's actually insurance that borrowers pay in case they get behind on their mortgage. It guarantees to a lender that they will be paid in full as well. So those premiums can be part of those statements. So that's one way to look. You can also look at the security instrument, the mortgage, a note, and there you can find oftentimes an FHA case number, or it defines the secretary as the HUD secretary. So there's little ways within the documentation that you can see here that can help determine that. You can also contact HUD's National Servicing Center to make that determination. And I would also say that our HUD-certified counselors are great at helping homeowners navigate this and make this determination. For VA loans, the mortgage or the note is going to have it on there that this loan is not assumable without the approval of the Department of Veterans Affairs. They often too include a rider, which is an additional kind of amendment or part of that mortgage that has on it that it's this specialized rider. So these are documents that most homeowners may have from their closing or have been recorded against the property and are in public records. So it can be, again, a good way to identify if the loan is government insured. USDA actually has two different programs. I would say this is one of the more challenging ones to determine if the loan is insured. However, you can send what we call a request for information to the lender in order to make this determination. Don't worry, we're going to talk about that more here in our upcoming slides. But before we get to that, Andrea is going to take us through a little bit about what the mortgage servicer's role is.
Great. So we talked about the owner, and then we talked about the mortgage servicer. So let's see what a mortgage servicer is. So the mortgage servicer is not the owner of the loan. So very different from the owner. The servicer has very different responsibilities to the loan and to the borrower than the owner does. So next, we know that the servicer is an agent for the owner of the mortgage loan. So the owner will create the rules, the policies, but then the mortgage servicer carries those out. So they really are an agent of the owner of the loan. And the mortgage servicer collects and applies the monthly payment. So your homeowner is making payments to an entity. Maybe it's Ocwen, maybe it's Bank of America, maybe it's Wells Fargo. They are the loan servicer. They take those payments and apply the monthly payments. And we'll talk about how they might apply those payments when we talk about escrow in just a minute. But first of all, mortgage servicers, or next, mortgage servicers interact with the homeowner. This is why it's so important to know who the mortgage servicer is. Who is sending those monthly statements? Who is the homeowner making a payment to? Because the servicer is going to interact with you and the homeowner to try and mitigate any losses, to try and get that servicer back on track with their payments and answer any questions and correct any errors that might have happened. And then they hold money in escrow. So an escrow is an account if your homeowner is required to pay a certain amount to the mortgage servicer each month for taxes, property taxes, and homeowners insurance. They don't pay the taxes and insurance directly. They make a payment to the servicer. The servicer will then keep that payment in an escrow until the property taxes come due, and then they will make a payment to the town, and they will keep the homeowner's insurance money in an escrow account until that comes due, and then they will pay the insurance company. So they require a monthly payment each month from the homeowner to be placed in escrow to ensure that those things are being paid, because those items protect their interest in the property. So when I said earlier, they apply the monthly payments, when they get a payment in from a homeowner, they'll apply it to principal, the principal of the loan, any interest that's due, and then the escrow for homeowners insurance and for property taxes. And again, they send the monthly statements to the borrower to say how much is owed, and they are supposed to say how much was the last payment and how much is owed for this current payment and how was that last payment applied. So those are things that servicers are supposed to do, and hopefully they do, but they don't always do them correctly. So let's take a look at who are servicers. As we have said many times, they are different from the investor, the holder, the lender of the loan. And an important thing is that borrowers cannot choose their mortgage servicer. So when a homeowner takes out a loan, potentially with their local bank or a bank in town, the servicing of that loan is oftentimes sold or assigned to somebody else, like Ocwen, SPS, SLS, Bank of America, Wells Fargo, Chase. These are mortgage servicers. They will do what I just explained a mortgage servicer does. But the borrower can't say, oh, I don't like Wells Fargo, I want a different loan servicer. Unfortunately, they can't choose their servicer. So it's essentially you work with the servicer you have. So it's really important for them to have you helping them communicate and negotiate with these mortgage servicers to get out of default and avoid foreclosure. So why don't we go to the next section, which is understanding the foreclosure process. So it's essential to understand the foreclosure process before you can help a borrower avoid foreclosure. Foreclosure processes are very specific according to the state that you live in. So you really need to know what is the process in your state. What is the foreclosure process in your state? And we'll go through a couple different kinds of foreclosure process in a minute. But what is the state-driven foreclosure process in your state? It's important to identify the players and the general process of foreclosure before you start to help your clients. So first of all, who has the right to foreclose? Again, check your state law, but it's generally the current owner or insurer of the mortgage. They can change very frequently. These loans can be sold, so make sure you know who the current owner is, going back to how we determine who the current owner of the loan is. Again, the very first important first step to take is figuring out who the owner is, because that is who has the right to foreclose. It could be the servicer. It generally is not the servicer. Generally, the right belongs to the owner. Next slide. Yeah. The next slide is who is running the show. So the owner may have the right to foreclose, but generally it's the servicer who decides when to foreclose. They hire the attorney to do the foreclosure. They negotiate a settlement, do the loss mitigation, all of that. It's really the servicer running the show with these foreclosures. But again, in accordance with the investor owner policies. There's a foreclosure attorney involved. They usually have a high volume of these cases. They're trying to push through and get to a foreclosure sale. And in some states, there's a foreclosure trustee. And this is a third party who oversees the process of foreclosure. And this is in non-judicial foreclosure states. And in a minute, we're going to tell you what that means. Next slide. So just one important federal law to keep in mind, and this is for all states because it's a federal law under Regulation X. The servicer cannot make the first foreclosure notice or file for foreclosure in any state until the borrower is more than 120 days delinquent. So until they're about 4 months behind, the servicer cannot, or the owner cannot initiate that foreclosure. They may threaten to do that, but if the borrower is not 120 days behind, they can't start that process yet. So that's a really important fact to remember and a tool to have. So I'm going to pass it to Stacey to talk about judicial and non-judicial foreclosures.
Thanks, Andrea. So as Andrea mentioned, some states have what's called a judicial foreclosure process. And typically what we mean by that is that there's some court involved who's overseeing this process, often involves appearances in court and various steps or requirements in responding to the judicial foreclosure, and again, just providing that oversight. Now, there are also states that have a non-judicial process. As Andrea described, these more often may involve a foreclosure trustee that is overseeing the process. In this non-judicial version, oftentimes it is through public notices and recording of public records that you can track and see the process. However, some states, my own included, California, have both processes. They have both a judicial and a non-judicial foreclosure process. Even though we have more than one process here in California, typically most of the lenders will go through the non-judicial foreclosure process because it is a bit faster and sometimes, and oftentimes I would say, less costly than going through a judicial foreclosure. Now, they will give up some benefits of that in California, at least. In California, if they choose to do a non-judicial foreclosure, that then means they cannot go after the homeowner if the home sells for less than it is owed. It means they can't get what we call a personal deficiency judgment against that homeowner. However, if they use the judicial process, they may then have that ability to get a deficiency judgment against the homeowner, which sadly means in those circumstances, not only will the homeowner lose their home, but they're also going to end up owing money afterwards and paying back the remainder of the balance due. So now what I'd like to do is just take you through some examples so you can see how this process works and in general the timeframes in which it can occur. The example we're showing you right here is an example of a non-judicial foreclosure from the state of Massachusetts. You can see here that there is requirements for notice as well as filing of information. And if you're looking at this in the overall timeframes, you can see here that a non-judicial foreclosure can take a matter of months to occur, which is honestly very quickly if you're thinking about and considering the loss of a home. We'll give you another example here of California's non-judicial foreclosure process. You can see again, we're looking at about a 7-month time frame for this to happen. The good news is when someone is in foreclosure, whether it's non-judicial or judicial, they can continue to try to work with their lender to see if they can't try to save the home. But as you can tell, again, it's very fast, so time is of the essence. And we can again compare this non-judicial foreclosure process to what it would look like in a judicial foreclosure state. So we're giving you an example here of Maine. You can see here again, there is a requirement to provide notice. There's a notice of default that looks very similar to the non-judicial process. However, then our courts step in where there's a complaint filed in court. The homeowner will have an opportunity to respond. But what is great sometimes about the judicial foreclosure process is across the country, there are a number of what we call court-sponsored foreclosure mediation programs. These can be a great opportunity to allow a homeowner to meet with their lender and try to see if there's a way to work this out in order to minimize the negative financial impact on our homeowners. And so that is an example there. Now what happens at this point after they go through the foreclosure, now this happens both in judicial and non-judicial, is that there is a foreclosure sale. And what that often looks like in most states is what I call a sale on the courthouse steps, where the buyer has to come in with cash in order to make a bid on the property, oftentimes sight unseen. Then what happens is that that bid goes to pay off the loan balance. And we do show here on the slide the order in which things get paid. If it does happen that there's a surplus from that sale, it would actually go to the borrower. But as I just described, these cash sales on the courthouse steps typically do not result in high bids. Oftentimes instead, homeowners walk away not only losing their homes, but also owing some additional money to their lender on top of that. And so this is, again, just giving you a little bit of an overview of how the foreclosure process works, the different time frames that are involved for that. But before we go kind of any further in talking about tools to help our homeowners here, I do want to go back to Araceli to talk a little bit more about what happened with her homeowner that she described to us at the beginning of our presentation and when she began working with him within this foreclosure process.
Thank you, Stacey. Okay, going back to my client, the one that had a terrible accident at work. Well, the first thing we did is to identify who the investor of his mortgage was. In this case, he had an FHA loan. So we had to follow the waterfall with FHA. He was going to apply for Social Security disability benefits, and you know that can take time. So the first thing we did, we found an attorney through legal aid, a wonderful attorney that we have here in Arizona, so he could apply for Social Security disability benefits. In the meantime, we contacted the servicer, and the first thing that was offered to him, it was a forbearance. He was able to skip payments for about 6 months, I believe. This was in 2015. Try to remember everything. So we applied for that. We prepared a loan package for that servicer, and he was reviewed for a forbearance. Luckily, he was approved for Social Security disability benefits. We contacted the servicer one more time, and then he was reviewed for a HAP modification, FHA HAP modification. At that time, we had the Obama's modification program. He was able to get approved for a good modification at a low interest rate. Those modifications that I'm sure you remember, the step rate mods where you start with a 2% and then it goes up to a certain percentage and then there's a cap. He was able to have an affordable payment after that. He was able to receive income. The wife had to start working because he was just a housewife. But you know, we were able to find a solution to this distressed client. When they were at my office, they were in tears. They didn't know what to do. So that's one of the things that why it's important to work with a HUD housing counselor. We provide options. Keeping a house might not always be the solution, but in this case, we were able to help the borrower remain in their home with an affordable payment.
Thank you, Araceli. And I just love that description you provided because it really shows the value of working with the HUD-certified counselors. I know oftentimes homeowners that are struggling will start out first with a community-based organization, but your description really shows that the value of HUD-certified counselors and all the different steps they can take, as well as then connecting them with our other partners on the call as well, with our legal service providers who can step in and work in different ways to help homeowners. Now, I know we heard in that last description a lot of references to what the options are and some different things like modifications and forbearances and things of that nature. So let's take a moment here and again, take a step back and start looking at the tools to start helping homeowners through this process. And for this discussion, I would like to go ahead and turn it back to my colleague Andrea here to start talking about some of the basic tools to help homeowners.
Terrific. So as you heard Stacey talk about the foreclosure process, we definitely want to avoid the foreclosure process. Not only does it have an incredible financial impact on homeowners, but the emotional and mental impact as well is devastating for homeowners. So we want to try as much as we can to prevent the foreclosure from happening in the first place and do what Araceli did to help her homeowner really look at options, explore options from multiple angles so they wouldn't have qualified for relief based on their current income when they came into her office, but then she helped them acquire more income through Social Security by helping them connect with a Social Security attorney and getting those benefits, and then they were able to qualify. So it's that problem solving. And before we can problem solve like Araceli did, we need to know the basic tools that are available for homeowners. So let's take a step back and unpack what Araceli was talking about with her homeowner. So first of all, one of the basic tools you can use is a letter, a particular letter that we'll go over, that you can send to the mortgage servicer, not the owner, but to the servicer. And you can help the homeowner send these letters. And these letters, under federal law, the servicer has to answer them. So you can get answers to questions of who owns the loan, how much the homeowner owes. You can let the servicer know that there was an error if they didn't apply a payment correctly, or if the homeowner is actually current on the loan, or the amount alleged owed is inaccurate. You can assert that error to the servicer, and you can ask the servicer what options are available to help this homeowner get caught up and get current on their loan. So let's take a look at these letters. What are they? So under federal law, they're called qualified written requests, or QWRs. And there are two specific types of QWRs, and they have their own acronyms, RFI and NOE. So request for information is an RFI, a notice of error is an NOE. And for both of these, it's really important, these letters have to be sent to the servicer's designated address. So there will be an address either on the monthly statement or on the servicer's website for QWRs, RFIs, or NOEs. So you're going to look for those terms: qualified written requests, request for information, notices of error. You're not going to send the letter to the consumer service address or the payment address. You're going to specifically look for one of these addresses, and that's where this letter has to go in order to for the servicer to have to comply with the deadlines, and for your client to get remedies if the servicer doesn't comply, because it's a federal law. So let's go to the next slide. What do these letters have to include? They have to have the borrower's name. You have to identify the mortgage account somehow, the loan number. You have to provide a request of specific information that you want. It just can't be a blanket request for all the information related to the loan. You have to have specific requests, or you have to allege a specific error. Hey, you didn't apply my payment correctly, or hey, you know, this is the wrong amount owed. I had a modification and now I owe this amount. You have it wrong. Whatever that specific error is, you have to allege that in the letter. And if you are sending this, if the housing, as you as an attorney or a housing counselor are sending this directly on behalf of your client, then there has to be a third-party authorization form so that the servicer will talk to you. We suggest that it might be better to help your client write this letter and send it on their own, certified mail, and make sure they pay for that certified mail, and that they alert you of any response that they get. If you can trust your client to connect with you, to communicate with you, if they get a response to this letter, then that might be preferable, that they do this on their own and you help them do that. So next slide. So the servicer, there are, so going back just a couple, there are specific deadlines that the servicer has to comply with. So if we go back one more, the servicer has to acknowledge receipt of your letter within 5 business days. If your letter is one of those letters under federal law, QWR, RFI, NOE, if it fits with the elements of those letters, then they have to respond and acknowledge that they got your letter within 5 business days of receiving it. And then they have to conduct a reasonable investigation and respond back to you within 30 business days. They can get an extension or ask for an extension of that, but in general, you're going to get an answer within 30 business days. So that's really important. It's not going to be this never-ending chase for an answer or waiting. They have to respond, or else they will be in violation of this statute. Next slide. So specifically, a request for information, you can ask for information relating to the servicing of the mortgage loan. So that's very broad. So you can ask who's the owner of this loan. You can ask for a payment history. You can ask for anything that's related to the mortgage loan. You can ask, how were my escrow payments applied? How much did you pay to the town for my property taxes? You can ask whatever information you want related to the servicing of the loan. And they have to provide that information within the 30 business days, or explain why they're not providing it. Next slide. And likewise, with the notice of error, the servicer has to correct that error. So you have to allege a specific error. Hey, you didn't apply my payment correctly. You should have applied this amount to principal, this amount to interest, and you didn't do it right, and you applied it to the wrong month. Well, they have to investigate that, and they have to correct that, or provide a written notice as to why they didn't correct it. They too have to conduct a reasonable investigation and let you know what they found out. So these are very powerful tools that you can help your homeowner do. You can help them write these letters and send these letters to the mortgage servicer to get information or try and correct certain errors with the loan. Next slide. So what if the servicer doesn't respond and you've sent several notices of error or requests for information and they just haven't responded, or they didn't correct the error and they didn't do what they were supposed to do? Well, if you're an attorney or a housing counselor, you can connect with an attorney, you can assert these violations, and your client would be entitled to actual damages. So this might be interest, fees, or charges that accumulated while they didn't correct that error or didn't do what they were supposed to be doing. It could be statutory damages up to $2,000 if they continually failed to respond to these requests for information and notices of error. And if you're an attorney bringing this claim, you can get your fees and costs paid by the servicer if you're successful. The homeowner doesn't have to pay you. You will get paid by the servicer. It's a fee shifting statute. It does have a statute of limitations of 3 years, so just keep that in mind. But generally, these letters can be very powerful in helping get information and solve errors that might be happening with the loan. So I just wanted to go over those letters first. Now let's get into some of the loss mitigation options that Araceli was talking about with her client. So loss mitigation, what we mean by that is a way to mitigate the losses. So really a way for the homeowner to mitigate the default, to become current again on their loan, or if they are unable to become current, to exit their property gracefully without incurring a huge deficiency or financial trouble. Ideally, the borrower will work with the mortgage servicer to create a plan to avoid foreclosure. But mortgage servicers can be very difficult to connect with. They can be very difficult to get an answer from, and they can provide different answers. They can be non-responsive. They can provide inadequate information or incorrect information. So that's why it's so important for you to help homeowners when they're trying to navigate this with the mortgage servicers. So next slide. So the different types of loss mitigation, the first one is a loan modification. We're going to go into that very generally. But another option is a forbearance. And you heard Araceli talk about the forbearance for her client. They got a 6-month forbearance. What does that mean? That means for 6 months, he didn't have to make his mortgage payment. And we heard a lot of these happening during COVID, and a lot of people were getting COVID forbearances, and it was for 6 months, 12 months, or even up to 18 months. They wouldn't have to make their mortgage payment, but that didn't mean they didn't owe their mortgage payment. They still owed those 18 months of payments. So at the end of that forbearance, they would have to find a way to pay those 18 months of missed payments, whether it was through a loan modification or some other type of repayment plan. A repayment plan is another type of loss mitigation option where the borrower pays a little extra each month to catch up on their loan. That usually is not a very affordable option for most borrowers because you have to make your regular monthly payment plus a little bit more to catch up. And then reinstatement is the ultimate loss mitigation where the borrower somehow has been able to come up with those 18 months of payments and just reinstate the loan and pay them all at once. That's very rare. I don't think you're probably going to run into that very often, and they may not need your help if they can just reinstate the loan. So, and then bankruptcy we'll talk about at the end for just a little bit. So let's go to the next slide and look at loan modifications. Very generally, what is a loan modification? So if it's a loan modification, it's going to change the terms of the loan to address the current arrears and to bring that loan current again. So the loan terms are going to be changed. It modifies the loan. One of the options is what is called a cap and extend modification. So essentially, the amounts that are past due, say somebody owes $10,000 in past due payments, and their loan they owe $100,000 in principal on their loan. If the servicer does a cap and extend, they will capitalize that $10,000, meaning they will add it to the principal balance. So now the principal balance is $110,000, and they will extend the term of that loan out. Maybe there was only 10 years left or 20 years left. Now they'll extend it out to 30, sometimes even 40 years to get to a target payment, because the longer it's extended out, the less the borrower will have to pay each month. So that to get to a certain target affordable payment, the servicer might extend the term out to 40 years. They used to lower the interest rate when the market interest rate was at 3 or 4. Now it's closer to 6. And so you're not going to see a reduction in the interest rate really very much now. You may see the interest rate staying the same, but you probably will not see a reduction in that interest rate if the current interest rate is already below the current market rate. Now, we also have what's called a deferral, where the servicer can place that $10,000 on the end of the loan. So the borrower will pay the $100,000 over the course of 20, 30, 40 years, and then at the end of that term, they will owe the $10,000. The $10,000 doesn't accrue interest. It sits there in a balance, and if the borrower sells or refinances or comes to the end of the term of their loan, they will have to pay that $10,000. And you can see here the cap and extend can be combined with the deferral. So you might have a borrower who owes $100,000 on a 20-year loan, but they can't afford that. That is that is unaffordable for them to make a monthly payment on that. So the servicer may take the $10,000, put it at the end of the loan, and extend the term of that 20-year loan out to 30 years. And now all of a sudden it becomes affordable on a monthly basis. So you'll see a combination of those. And I did just want to toss it back to Araceli, if you're there for just a minute. You talked about an FHA HAMP loan for your borrower, and HAMP was a program in the mid-2000s that helped borrowers catch up. Do you remember, Araceli, was there an interest rate reduction, or did they extend the term out? Do you remember how they
Yes,
got?
Sandra.
Go ahead.
Yes, Sandra. Actually, they started with the step rate modification. They started with the 2%, and it had a cap at of about 5% within 5 or 6 years. They extended the term and to make it affordable. And I think there was a deferment also, because at that time, some modification programs had a deferment where they can cut 30% of that unpaid principal balance and put it on the back of the loan to make it more affordable.
Yes, yes. So that's a perfect example of a combination of these different elements that can be used to bring a homeowner current again. You're not going to see the 2% step, but you may see the interest rate staying the same and then the term extending out and some of that past due amount put at the end of the loan. So if we go to the next slide, if Araceli wasn't able to connect her client with a Social Security attorney and her client wasn't able to get the SSDI benefits, it's unlikely he would have been able to afford a loan modification. And so he might have been looking at what we call a graceful exit. And that is when a borrower has to leave the home. There's no possible combination of relief options available to help that borrower stay in the home. And sometimes a graceful exit can be beneficial to a homeowner. And a graceful exit could be negotiating time for that homeowner to sell the property through a real estate agent, where they'll get a better price than what Stacey was talking about, a foreclosure on the courthouse steps. They'll definitely get a better price if they can sell it on their own through a real estate agent, or negotiate a short sale with the servicer. What a short sale is when the homeowner owes more on the loan than the home is worth. So take our $100,000 homeowner who had $100,000 principal. If that home was only worth $70,000, they would have to do a short sale and hopefully negotiate a waiver of that extra $30,000. Then there's also a deed in lieu of foreclosure, where the homeowner can give the deed back to the servicer and owner of the loan, and agrees that a foreclosure will happen. They won't have to go through the court process, and they can sign over the home in lieu of a foreclosure instead of a foreclosure happening. And this can only happen, though, if there's only one lien on the property. Generally, this does not happen if there is more than one lien on the property. And just, Araceli, these graceful exits are really difficult, but is there ever a good time when can this ever result in a benefit to the borrower to have a graceful exit?
Yes, I have a story that when you tell me, I'll share with you guys,
Yes.
Sandra, because like I mentioned at the beginning, keeping the house might not be the best solution to a client. So I had this lady, a senior female, she became a widow. She was about 66 years of age. She lost 50% of her income, of course. The house was no longer affordable for her. She was about to face foreclosure, couldn't afford a modification because her income was really low. We went over options, and one of them was to let the house go. And at first she looked at me, but I was able to find her a brand new apartment where she was only going to pay 30% of her Social Security income to cover rent, utilities, and maintenance. I was really sad because she was losing her home. But guess what? One day she came and knocked on our door with food, tamales and cookies, and she said, Araceli, I just came to say thank you. And I looked at her and I said, you lost your home. And she said, yes, but that was the best thing that could happen to me. You got me a brand new apartment in a senior community. I have friends. I have people that I can play cards with, and I don't have to worry about maintenance. And that shocked me. And I gave her a hug and I said, oh my God, so I did the right thing. As counselors, we have to be honest. If someone cannot afford the home, you just need to find a solution that will make them happy, even if they lose their home.
Yes, that is fantastic, Araceli. Thank you for sharing that story. And there, the graceful exits, there are minimal other relief options available than what we just went over. Stacey's going to talk about a couple other options you should definitely explore with your homeowner. So I'm gonna pass it back to Stacey.
Thank you both. So what I'm going to talk about next are some mortgage relief programs that are currently available. The reason we've put this after the description that we just provided to you is because many of those loss mitigation options we just described is a process that either HUD-certified counselor or legal service provider may help to work with our homeowner and their mortgage servicer to try to achieve. Whereas some of these programs that I'm going to describe are more about getting a relief to the homeowners through another entity. So one such program that is currently available is the Homeowners Assistance Fund. Now, the Homeowners Assistance Fund was actually authorized by the American Rescue Plan and provided almost $10 billion in relief in order to support homeowners who are facing financial hardship associated with COVID-19. So with this program and what is available, the states were allowed to design their own programs on how to give out this assistance. And they could set a lot of the different requirements for that, including whether or not the assistance can be used for a mortgage reinstatement or to help achieve a loan modification. It could also be helpful or used in order to help homeowners make critical repairs on their property or such things of that nature. And so the plans do vary from state to state. And actually this money was given out, I believe, almost 2 years ago. And so the reason we waited to mention this is because, as you can see on this slide here that we are looking There are a number of states that had the Homeowners Assistance Fund, but have actually already moved to close their programs. So that includes those states that are in this kind of dark gray color. Those states are no longer offering the Homeowners Assistance Fund program, and they have closed their programs. Those that are in that kind of pale bluish grayish color, like Oregon, Indiana, Tennessee, those states have moved towards closure. That means they may have suspended their programs or moved to a wait list. Now, there are some exceptions to that we can be looking at here. That includes Pennsylvania. Pennsylvania actually had to go through a temporary suspension of their Homeowners Assistance Fund because of some transitioning in the administration, but we are hoping that program will be reopening. The Tennessee program is open, but the reason it's in this blue-gray color is that they are no longer providing assistance with reinstatement. Now what they are doing is just helping to pay off partial claims or those deferred balances that Andrea described from the loan modification program. But of those states that are still open and accepting applications, this can be a wonderful benefit to your homeowners. And the reason I say that is, and I'll just give a brief example of what is available under the California Homeowners Assistance Fund to give you a sense of how big of a difference that this could make for our homeowners. And so in California, the Homeowners Assistance Fund there will provide up to $80,000 to homeowners in order to allow them to reinstate their mortgage. That benefit is given to them as a grant. That means after the fact, they will not owe money on that. So unlike the description of a deferred balance or a partial claim, that amount will not become due and owing at the end of it. Now, also in California, their Homeowners Assistance Fund will help provide payments towards property taxes. A number of other states will do that as well. So if a homeowner gets behind on those property taxes, they will pay those. Now, California's program is a bit more limited in focusing on paying mortgage reinstatements, partial claim balances, and property taxes. They also have a specialized program to help homeowners who have a property assessed clean energy assessment on their property, but that's a little bit unique to California. Some of our other states that are open here as well and are offering additional programs above what I described. Some of the open states will also offer assistance in paying off past due utility bills or utility expenses associated with the property. And a few other states have recently opened critical home repair programs. Those programs are designed to help homeowners who may be struggling with, let's say, a failing roof on their property. It may help them replace that roof so they can maintain the property and stay in it for a long period of time. Now, this again is the Homeowners Assistance Fund. This comes from national federal funding that is then provided in which the states are distributing that. So again, you can monitor these programs, and most of the programs do have websites where you can go and see the requirements of that program. But just stepping back again, I do want to mention that there are some state programs that do something similar. So the New York has a New York Mortgage Assistance Program that will provide up to $80,000 to eligible New Yorkers for assistance. Now, instead of being a grant program, theirs is set up as a 0% interest loan on the property. Oftentimes, these are then forgiven over a certain period of time. In addition to that, you may find more localized programs. For example, in California, the County of Alameda has a very special mortgage reinstatement program for small mom and pop landlords who maybe are renting out a room or an ADU unit on their property, and they can get mortgage assistance. I only mention all of those because this is really what I think is very valuable about relationships with community-based organizations, as well as with HUD-certified counselors, to help homeowners navigate all of these different benefits that may be out there to them to help them save their homes. The last option we do want to mention is bankruptcy. Now, this is an instance in which having a legal services attorney or an attorney involved in the case would be really important, because what they can do is help assess whether or not a Chapter 13 bankruptcy will help a homeowner in addressing their precarious financial circumstances. It can be challenging because those homeowners are going to have to pay off their arrearage plus the ongoing balance as part of this plan, and often requires an assessment and analysis of other outstanding debts and concerns that may be making that mortgage unaffordable. So again, we just want to highlight this as another option. Bankruptcy can be a way to slow down the foreclosure process, to open up some more opportunities, or to open up opportunities under Chapter 13 with a payment plan on the arrearages. But again, for this, I think it's great to have a lawyer involved, and hopefully in going through these descriptions, you are starting to get a sense of all the different players that are out there in order to help homeowners. Another big thing that can help in saving homes is legal defenses or different legal claims that can be brought against either the lender or the mortgage servicer. Right now, I've just put a slide here to give you just a general idea of all the different defenses that can be raised by legal counsel. So if you get to a point in working with a homeowner where many things have been tried, but they continue to fail, or let's say, as Andrea took us through, you've been trying to get information from the servicer and they're simply not responding in violation of RESPA, these are all great opportunities to involve an attorney in the case to help assess and determine if a legal defense may be able to help save the home and prevent that loss for the homeowner. We're not going to regrettably have time today to go through what all of these are and the different ways they can be used. But again, just wanted to point it out so that everyone was aware that there are legal defenses in foreclosure that may be an option. And that, again, is a great time to start involving an attorney to look at the case. I would also say oftentimes having an attorney involved in the process, even through that loss mitigation process, can help to identify claims, in particular under the Truth in Lending Act or under RESPA, as well as, again, if it's in that foreclosure, looking for and making sure that the servicers and lenders are following the foreclosure requirements and taking each of the necessary steps to ensure that the homeowner has every available option to save the home. But now we want to spend a little time just talking about how we can all work together to support homeowners and hopefully help them through this process. So as we start talking about this, I did want to go ahead and turn the mic back over to, and actually, sorry, quick, just to share with you what we mean by this, to working together to support homeowners. You know, we do just want to point out there is a lot of assistance available to help homeowners with this. First and foremost, which is not on this slide, but that I would say from my own experiences working in this area, community-based organizations that are out there working with homeowners really are what I call the canaries in the coal mine. They're oftentimes hearing of concerns that homeowners are raising that otherwise may not come to the attention to HUD-certified counselors or legal service providers. That oftentimes maybe where a homeowner turns first is to a trusted local community-based organization that is within their neighborhood in trying to find that assistance they need. And so again, this slide doesn't have that on it, but I did want to just highlight and in a way take a step back as to, you know, kind of pointing out that value of working and developing relationships with community-based organizations that serve the populations who may be experiencing these financial difficulties. Other assistance that is available are HUD-certified counselors, legal service providers, as well as, we mentioned this earlier when we talked about foreclosure, there may be foreclosure mediation programs that are also part of this process that can provide assistance as well. But now what I'd like to do is turn the mic over, and Araceli, could you talk to us a little bit more about what the role of HUD-certified counselors are and how you help homeowners through this process?
Sure. Now, why is it important to work with a housing counselor? As Stacey and Sandra mentioned, there's benefits. So let's talk about those steps when someone just come to us and we try to assist them. The first thing to do is assess the client's goals. The first question I will ask is, do you want to keep the house? If they say yes, then we have to identify who the investor of the loan is. Why is it important to find out who the investor is? Because each investor that Sandra mentioned, like Fannie Mae, FHA, VA, all of them have their own guidelines and they're different. You have to be involved in those guidelines. The next step is to assess a budget. A budget is a way to balance your income, expenses, and financial goals. How many times have you asked yourself, where is my money going? Sometimes they don't know how to identify those things. Financial goal could be for a specific length of time. For example, I want to buy a home. Let's work on your budget to help you achieve the goal. Or let's cut unnecessary expenses to be able to stay in our home. Those I call it the key of success. We have to start with a budget. For example, the things that we do, qualified written requests. As Sandra mentioned, it's important to have someone resolve those errors. For example, if you find an error on that account, we will help the client fax or mail a written request. There's many errors on escrow accounts, for example, that I found during this time. And my job is to help them write the request, fax it to the servicer, and make sure that the servicer corrects those errors. Contacting the servicer. If we help you with that call, the chances of obtaining a good result are higher since we understand the language of the servicers and the home retention options. Sometimes I will have a client sitting in front of me and I'm talking to a lender and they will talk about DTIs, LTVs, and the client looks at me like, what are they talking about? That's why it's important that you sit with that client and make a call to the servicer. Assist clients completing a loan modification package. This one is very important. This process can be overwhelming for a client. We know exactly how to prepare them, and we make sure that everything is answered properly. We also make sure that it's sent complete and with the required documentation. Another step, if the work edit's approved, I will recommend to schedule an appointment, have the client bring the loan modification agreement to you, explain the terms to the client, and have them sign if they agree. Because most of the time, believe me, not all the time, clients will agree. I had modifications where they had balloon payments. You have to explain what a balloon payment is, and if they agree, sign, notarize, and send it back to them. The last step is to prepare a new action plan and a new budget at the end. Just plug in the new mortgage payment, make sure that they cut some unnecessary expenses. It's funny to say that this will be the last appointment because I have clients forever. They will, if they trust you, they will always come back to you for any reason. Be resourceable. Always have resources available. Clients don't call here just because they have a housing issue. They call because they need legal assistance, they need medical insurance, or to file for divorce. And those are one of the things that we make sure that we are resourceable. Thank you, Stacey.
Well, thank you for that. And we did just want to highlight here for you, for everyone, times in which it may be a good idea to refer a case to a legal services provider. And I apologize, it appears, oh, here we go. My slides have locked up again, so I think they're going to advance. There we go. We did hear a little bit about when, oops, now they're going crazy. Okay, catching up to me. So I'm going to go back a little bit. We did get to hear about, the role of housing counselors. And then Sorry, still going back here. And so this slide here, kind of when to reach out to housing counseling, I think is very helpful. I mean, as we heard in the description, they play such a vital role for our homeowners. And so this, again, just gives you some idea of when it can be great to have a housing counselor or make a referral to a housing counseling agency to help our homeowners. And then last, we wanted to share with you when it can be good to reach out to an attorney. Oftentimes, if there's already a pending foreclosure judgment or a sale, or one coming up, this is a good time to get an attorney involved. I definitely recommend legal services counsel if it's a judicial foreclosure and having them part of the process. But even in non-judicial, they can really make a difference in looking and ensuring that the proper process is being followed. Another time is if the servicer is being unresponsive and not getting back with the necessary information or willing to provide options or discuss what those options are. We did just briefly touch on there may be defenses that are out there that a homeowner can assert. And so that can be another time to do that, as well as if there's issues with the notice of error or request for information, or there's a need to help in reviewing that material in order to help the homeowners and potentially save the home. So that is just, again, a very broad overview of foreclosures and how to help homeowners through this process. If we've got you excited about this topic and wanting to learn more, we did want you to save the date. The National Consumer Law Center has an amazing mortgage conference that they host every year. This year's is going to be virtual, June 3rd through the 6th. And it is an amazing way to learn about foreclosures. I would say, what was it, 2 decades ago when I started in this, it was through NCLC's mortgage conferences that I learned all the different ways to help homeowners and gain my confidence in representing homeowners through this process. So on that note, just want to thank everybody for being here. And then I think we're going to open it up or hear if we have any questions.
Thank you so much, Stacey, Andrea, and Araceli for that presentation. I'm going to actually bring on Consumer Action's Monica Steinish, who's going to help us with questions. Monica, if you're there, did you gather questions from our participants?
Yes, I did. We have some good questions. And the first one is this person says, the biggest problem he's seeing with his clients is that loan servicers are not following RESPA regulations with regard to filing loss mitigation applications, and also that loan servicers are not sending clients to them for help until the loan servicers are not sending the people who are at risk of foreclosure to this counselor until the 11th hour. And how can they address those issues with the way loan servicers are handling things or not handling things?
That is a wonderful question. Hello, this is Stacey, since I know you can't see me, with the National Housing Law Project. And I just wanted to jump in response to that. And regrettably, it's not uncommon that this can happen. I would definitely recommend in situations like this, especially where you see this happening with any particular servicer, it may be a problem you see with one more so than others. It can, again, be a great opportunity to connect and work with a local legal services provider so they can help assess and look at those options of potential violations that could actually be litigated. As we mentioned earlier, that RESPA does have violations, and so those are some things that can even be affirmative litigation in those cases, or used as an affirmative defense or counterclaim in the foreclosure process. Another opportunity to address this as well can be filing complaints with the Consumer Financial Protection Bureau. This is a way to notify the CFPB that a servicer is not following the processes that have been outlined. In fact, oftentimes when the CFPB receives significant complaints or a large number of complaints involving a particular servicer, this can spur them into action, greater supervision, or oversight of that mortgage servicer and their practices. But I don't know if any of my other panelists wanted to jump in on that as well, recommendations.
Yeah, I totally agree with Stacey, everything she said. And I also want to encourage you to be proactive, because servicers are not going to refer borrowers to housing counselors or legal services attorneys necessarily, and not to wait for them to try and refer someone to you. Try and be proactive, connecting with community groups, other community groups, church groups in your community, to try and get the word out that borrowers should connect with you, what a housing counselor can do for them, how a housing counselor can help them. And I'm sure you're probably doing this, but really trying to get the word out for people to come to you before they're in court with a foreclosure action, you know, right at the beginning when they're falling behind, trying to get them through the door to help them with this, and maybe building alliances with your local legal services so that if they're seeing clients, you can help with them with the numerous clients that are coming through their door. Like Araceli said, you can help do the budget screening and get a lot of the information and work done for them, and really partner up with them to help these clients, to help more clients, and really be proactive about doing that.
And something else very important I wanted to mention here, always get the client involved. Train them how to follow up with servicers. Don't wait for the servicer to call you and request an additional document. That's one of the things that I always make sure to get them involved. This is their home, and you always have to mention that to them so they can get involved and make the follow-up calls at least once a week. Don't wait for the servicer or anybody else to call you.
Great, thanks. Great information. We have another question. This person wants to know, what do you do when a servicer offers a modification at a higher payment and interest rate than the original loan? They've seen loan modifications with the current mortgage interest rate in New York between 6 to 7%, when most of the clients had a mortgage interest rate of under 5%, and then the trial mortgage payment ends up being higher than the current mortgage payment.
This is a very difficult reality right now, because mortgage servicers are not lowering the interest rate, as I said earlier. They're going with the market rate, and some investors require them to offer the market rate, which is 6 or 7%. So it's very difficult for many borrowers right now in this landscape. And there's not a lot you can do, because these are investor rules and the rules of the owner or investor of the loan, and that they can't reduce the interest rate below market rate, and that if they do modify the loan, it has to be at market rate. And since market rates are at 6 or 7, that's where it's going to be, and it may make the payment higher. And so unfortunately, there's not a lot that you can do. I mean, potentially you can try and ask that the rate stay the same so that it at least doesn't increase, but some investors are requiring that increase. And so the options for some homeowners are very difficult, and they're not going to be affordable. And so maybe you have to do a plan B. Maybe you look at bankruptcy if that's an affordable option, and some of the other options, the Homeowner Assistance Fund options, if that's still available in your state, and some of the other local options that might be available.
What I've seen lately, most people have an FHA loan. Unfortunately, they just bought their homes 2 or 3 years ago, and a partial claim works much better for them. It's just to put in the arrears on the back of the loan, and it doesn't change the term. So luckily, that's what they will get at the beginning, a partial claim.
Great.
Monica, if I could jump
Thanks.
in, if I could jump in just for a moment, Monica.
Yeah.
Let's go at least another 6 or 7 minutes with questions, because we had a little bit of a delay getting started. And all of this will be sent out in a recording. So most of the speakers told me that they had a little wiggle room. So let's do another 5 or 6 minutes.
Okay, great. Well, here's another one. Is there any legal requirement that the foreclosing entity sell the property at the highest market value? If so, are they required to use real estate comps to establish the price? Is there a beginning minimum bid against which bids must be made? And I assume this is to avoid a deficiency judgment. Are they responsible to get as much money as possible to pay the mortgage?
So that's a really good question, but it is very state specific. So every state has their own law around that. And so I would recommend connecting with an attorney familiar with the foreclosure process in your state to find out what the process is regarding the value that an entity must get at the foreclosure sale. Usually it's not a real estate broker sale. Usually it's not fair market value necessarily, but each state has different procedures. And in some states, if you don't follow the procedure, then the lender or servicer cannot collect a deficiency or the difference between the amount owed and the amount received for the loan. So it's really important to see what the process is in your state.
Okay. Okay. Are credit unions bound by the federal 120-day rule?
Yes. Yep.
That's an easy one. Okay. And then somebody else asks, does the deed in lieu
I'm sorry.
negate?
I'm sorry. I have to clarify that because, right, I'm an attorney. I got to clarify. But if they're a loan servicer, so if they service the loan and they're a loan servicer, then yes. Okay, so that's the clarification. Sorry, go ahead.
Okay, thanks. Does a deed in lieu negate tax consequences that would otherwise be incurred with a deficiency judgment?
I would say, again, I mean, it really depends on, and I hate to give a lawyerly answer, but, you know, I always like to look at the specifics of it. But I would caution people in response to this conversation is that if a debt is discharged, so for example, in a deed in lieu, if, for example, it is believed that the value, the amount of debt discharged was greater than the value of the property, a homeowner could receive what's called a 1099-C. This is a form that indicates that there's been a cancellation of debt, and the difference or that amount of cancellation of debt is actually supposed to be reported by the homeowner as income. In fact, in evaluating 1099-Cs, we find a lot of problems with these from servicers. Oftentimes they'll put the full value of the debt there and not account for the fair market value of the home and various things. And so, yes, being concerned about those tax consequences is an integral part of the counseling and ensuring that homeowners know and understand the implications of doing that. There are also some tax protections. So if there's a principal reduction and various things that may not be taxable. And I hope, as you can tell by my answer, it does start getting more and more complicated. And so really just want to flag that the cancellation of debt may have consequences for your homeowner for tax purposes. So making sure they know and understand those consequences is very important, especially as they're going through this process and considering their options with the property.
Great. Thank you. I know we've gone a bit over time, but thank you for the great presentation. And now Nelson can finish up.
Sure. Thank you, Monica, for those questions, and thank you, everyone, for staying on a little bit longer. I do want to remind folks that Consumer Action is a nonprofit national organization, and if you'd like to support us with a contribution, you can do so online or by mail, as this slide indicates. And also, you can support us without spending a cent by subscribing to our YouTube channel. That can be very helpful, and also following us on social media. We are very appreciative of any support that you can offer. I do want to once again thank Araceli, Andrea, and Stacey, as well as ARC, the National Consumer Law Center, and the National Housing Law Project for being at this webinar. Thank you for speaking in today's webinar. Hopefully, all three of you can come back and talk to us about another topic, or maybe we can dig into one of the topics from today a little bit more. Thank you, audience, for hanging on. We're going to see you soon. Watch your inbox for upcoming events. And please take the survey that should appear momentarily as we end the webinar. And will also be mailed to you in the follow-up letter. Goodbye for now. Thank you for being on. Thank you all.
It's been a pleasure. Thank you.
Yes, thank you very much.
Thanks so much.